Welcome everyone to this CAREX Canada webinar on practical tools for working on occupational cancer cases, case studies on lung cancer. This webinar is presented in partnership with the Industrial Accident Victims Group of Ontario Community Legal Clinic, or IAVGO, the Occupational Health Clinics for Ontario Workers, or OHCOW, and the Ontario Office of the Worker Advisor, or OWA. My name is Chantel Burnett, and I am a Research Associate for CAREX Canada and will be helping to moderate the webinar today. I'm joined by several others who will be presenting. Cheryl Peters, who's the Co-Principal Investigator at CAREX Canada, Laura Verma, who's a Legislative Interpretation Specialist at the OWA, Meredith Yaknin, who's a Staff Lawyer at IAVGO, Dave Wilkin, who's the Chief Operating Officer at OHCOW, and Anya Keefe, who's an occupational exposure expert and independent contractor for CAREX Canada. The goal of the webinars today is to provide practical tools for law and labor professionals working on occupational cancer cases within the workers' compensation system in Ontario. I will now have Cheryl Peters take over and provide an introduction to this subject area and frame the webinar for us today.
Thanks everyone for joining us today. My name is Cheryl Peters. I'm the Co-Principal Investigator of CAREX Canada. I'm just going to set the stage for our webinar today by giving you a brief overview of how this work got started within the context of CAREX Canada in advance of you being able to hear the very interesting case reports from our guest speakers. So for those of you who are not familiar, CAREX stands for carcinogen exposure, and the CAREX Canada project has been around for quite a long time now. It was originally funded as a pilot project by WorkSafe BC in 2003, and it was fully funded by the Canadian Partnership Against Cancer in 2008. The name CAREX actually wasn't developed by us. It comes from a project developed by the Finnish Institute of Occupational Health almost 30 years ago now, with support from the Europe Against Cancer program of the EU. And the goal of the original CAREX project was to estimate exposures in workplaces. However, unlike the Finnish CAREX, CAREX Canada is unique because it also includes an environmental component. We won't discuss that today, I think for obvious reasons, but we are mostly going to focus here on our occupational exposures component. The project itself estimates the number of Canadians potentially exposed to known or suspected carcinogens in workplace and community environments. And these estimates are meant to support prioritizing and targeting exposure reduction strategies and cancer primary prevention programs. So on to slide 5. How does CAREX Canada select our carcinogens? So we don't decide ourselves on what causes cancer or not. We rely on the evaluations made by the International Agency for Research on Cancer, or IARC. So IARC has classified over 900 agents into different groups based on their potential to cause cancer in humans. So this includes group 1, 2A, and 2B carcinogens. And so these group 1 are known carcinogens. So we know they cause cancer in humans, which means we have sufficient evidence in large epidemiologic studies. This includes things like benzene or radon, and more recently diesel engine exhaust. Group 2A are probable carcinogens. These are usually based on limited evidence of carcinogenicity in humans, but usually good evidence of cancer in experimental animals or from other sort of mechanistic evidence. Group examples of things in Group 2A include things like shift work and acrylamide, and Group 2B are possible carcinogens. So we're not too sure whether or not they cause cancer yet. There is limited evidence that they might cause cancer. So an initial task of CAREX was to identify which things that we would prioritize and work on. So we focus on 72 substances, and these were selected based on the potential for occupational and or environmental exposure in Canada, and with also some consideration of feasibility of assessing exposure. So we really wanted to make sure we had enough data sources in order to do a good job and provide some good scientific evidence for how many people might be exposed. So the next slide, slide 6, for our occupational estimates, these are the main project questions. So how many people are potentially exposed at work? Where do they work in terms of what their industry is? What do they do for their tasks or their occupation or job title? We also would like to know where they live and work in Canada, so then we can know sort of how exposures might vary by province. And we're also really interested in what levels they're exposed to. So who are the people who are at the highest risk of cancer because of their higher levels of exposure? So this slide here is just showing you who is at risk. You can see our top 10 known and suspected occupational carcinogens in terms of the number of people exposed. So everything listed here are IARC Group 1 human carcinogens, with the exception of shift work and lead. Shift work is an IARC Group 2A, or probable carcinogen, and lead compounds, the classifications there vary a little bit. So inorganic lead compounds are known as Group 2A, and elemental lead is Group 2B. Organic lead compounds are Group 3, so we can't sort of classify them as to whether or not they cause cancer. And I've also shown here the confirmed and suspected cancer sites for these carcinogens. So you'll see shift work coming out on top, suspected of causing breast, prostate, as well as colorectal cancer. Solar radiation is our next largest one, which is a known skin carcinogen, and then down the list you'll see asbestos showing up there at the bottom. Still over 150,000 people exposed, and asbestos confirmed of causing lung cancer, mesothelioma, laryngeal cancer, and ovarian, and suspected of several others. So why are these cases important to us at CAREX and to the broader law and labor professional community? So we know that occupational cancer cases are important because they're increasing in number, just at a most basic level. So we're seeing more and more cancer cases over time. And there's basically a preventable burden of this. So people are still being exposed to occupational carcinogens today, and we know that this will lead to cancer in the future. So if we can do something today, then we can reduce the impact of this going forward. They're also really important because it really requires us to assess past exposures, which is really challenging. So there's a latency or a gap in time between when an exposure occurs in a workplace and when that person is at risk of cancer. So cancer doesn't just happen today from an exposure you have today. Any cancers that you might be diagnosed with today are much more likely to be from exposures that you experienced a number of years ago. And that number of years really depends on the type of cancer as well. For more bloodborne cancers, this can be 5 to 10 years or longer. For things like asbestos, you might not see cancers showing up until up to 50 years later. And these cases are actually really important from a legal context, as well as I would say from just an occupational cancer standpoint. They're just very complex. So people have worked a lot of different jobs over their lives, and it's really hard for us to pinpoint what actually might have caused a cancer that they are being diagnosed with today later on in their lives. Another sort of piece of context that frames our efforts here is just that cancer is really important. Cancer is the leading cause of death in Canada. This isn't the same for all countries in the Western world. In fact, heart disease still is the leading cause of death in the United States, but cancer's now overtaken heart disease in Canada. About half of people with slightly different rates between men and women here will experience a cancer diagnosis in their life. So this is really important just for us as Canadians, but then we start to think about that a number of these cancers are very likely caused by work. It's important for us as occupational health professionals as well as legal professionals who are going to be dealing with these cases as they increase going forward. You can see also that they're important when we look at WSIB or long latency claims by disease. So you can see that the claim, and these are only accepted claims. So this is a vast underestimation of basically what occupational disease impacts are. These are ones that have been actually filed. So you can see mesothelioma, lung cancer, and prostate cancer and skin cancer showing up here as the allowed long latency claims, making up a good chunk of what we're seeing in terms of their accepted claims by disease. Pleural plaques are also related in general to carcinogens, and pleural plaques tend to precede occupational cancer for a number of diseases. So these really are all kind of these diseases that are either cancer themselves or are related to cancer conditions. If we look at those same WSIB long latency claims by sector, you can see, perhaps not surprisingly to those on the line, that construction and manufacturing, primary metals, and municipal municipalities are the primary sectors where claims are coming from. Schedule 2 is kind of a mixed bag of other industries. Why are these cases challenging? Well, they're very time-consuming and expensive compared to other cases. It's actually very difficult to collect exposure histories and have evidence of exposure. And usually there's sort of non-experts in occupational health that are actually responsible for figuring out these things. So there hasn't been this sort of natural fit between occupational health professionals and law and labor professionals to actually get together or have a way to communicate about what these exposures might be. Another big challenge that we've realized in our work with our partners on the line today, as well as other folks, is that the need to show causation is really difficult. It's really necessary from a legal standpoint, but it's not really easy to do that medically. And so there's this disconnect between what needs to happen in a legal fashion and what the medical community feels capable of doing. So interpreting the medical literature for this purpose and engaging medical professionals for opinions can be really challenging. And I think up until very recently, there hasn't been a lot of engagement with occupational health professionals who could really assist with this phase of the work. It's really difficult, as you could imagine, to say, look at a person who presents to you with cancer today and say, well, these are the things that specifically caused your cancer, especially when lots of workers are exposed to a number of different carcinogens, and they might cause a variety of different cancers, and they could be exposed to many of these different things at different times in their careers. So it's challenging for all of us that sort of work on these cases as professionals. Just a second slide on these cases and why they're challenging. So it's really difficult to determine the precise level of exposure that's needed to demonstrate work-relatedness. And this kind of differs by province and sometimes is not necessarily set on the best science. It's also really difficult to address confounders. So there are often synergistic effects of smoking. So a lot of cancer cases that come in are lung cancer. We're going to talk about lung cancer today. We do know that the main cause of lung cancer is smoking. However, smoking and occupational exposure to some carcinogens can actually multiply your risk of cancer rather than just having an additive effect. So if this is quite a complicating factor in these cases. And there's other lifestyle factors that could increase your risk of different cancers, lung cancer included. There's also the difficulty that we experience of the mixture of exposures and the assumption that exposures are additive only. And Dave's going to touch on this today in his case. So this is a really challenging piece, and the science sometimes just really isn't there for us to say otherwise, but we know that there are mechanisms that things can actually multiply your exposure, especially when seen together. So something like radon and smoking dramatically increases your risk, more than just if you were exposed to radon alone or if you were just a smoker. So these are really big challenges that we face from a scientific standpoint as well as from a legal standpoint. So I'm going to stop there and pass it off for case study number 1. But thanks so much for your attention, and I'll be available to answer any questions in our question period at the end. Thank you.
Thanks, Cheryl, for your introduction and framing our webinar today. I will now ask Laura from the Office of the Worker Advisor in Ontario to discuss the first case study.
So the case study that I'm doing today is talking about the issues around lung cancer and asbestos. As we know from what's just been discussed, asbestos is a group 1 carcinogen and it's known to cause lung cancer. So this is a regularly pursued type of case in the Ontario compensation system for occupational disease cases at least. And it in general has a greater chance of success than many other types, but there are often many hurdles. And so I'm going to talk about some of that. Next slide. So just before I get into my case study, I thought I would talk quickly about this sort of framework I use and how I look at occupational disease cases in thinking about how I'll focus my efforts as a representative. Often I consider that there's really 4 parts of each occupational disease case, that being the diagnosis, meaning what is the condition that they have, what are the exposures that they had in their workplace, And then third, the general causation. What is the link in general between that exposure and that condition? And then specifically, is there a link between this particular worker's exposures and their particular condition? And is that supported by a medical opinion in the file? I often use this sort of framework as a way to look at where there are gaps or challenges in a particular case, where I'll need to focus my efforts. When you're looking at lung cancer and asbestos, as we know, the general causation piece is quite strong. It's widely accepted that asbestos causes lung cancer, as we just talked about with IARC, as well as it's in a WSIB policy. So you really don't need to spend any effort trying to prove general causation in a case with lung cancer and asbestos. And also, if you are able to meet the policy, then you actually don't really need to do too much about specific causation either. So when I'm looking at an occupational disease case involving lung cancer and asbestos, I'm going to focus then on the first two, which is diagnosis and exposures. Next slide. So today I'm going to go quickly through these 6 listed topics. I'm going to talk about basic facts of the case, some discussion about diagnosis, a little bit about the policy in Ontario in regards to lung cancer and asbestos, some discussion of some case law and how the tribunal looks at that board policy, a little bit about the coworker evidence that was very important for this particular fact scenario, and then how the tribunal decided the case in the end. Next slide. As with both Meredith and Dave's cases, I'm going to be speaking about a case that has a final tribunal decision. It's not my case in particular. I didn't work on it. It's a public domain scenario, and so therefore I'm allowed to freely discuss all aspects of what's in the tribunal decision. So the facts of the case are as follows. A worker was diagnosed with lung cancer in 2010 at the age of 70. He filed a claim with the WSIB prior to his death in 2012. The worker, in filing his claim, attributed his lung cancer to his exposure to asbestos as well as silica when he worked at a foundry. In particular, when he was a molder at that foundry from 1969 to 83. As with many different cases that do end up in appeals, this worker also did have a substantial smoking history at 55 pack years. The WSIB looked at the case and had a hygienist prepare a written assessment, and in that, the WSIB did accept that the worker had been a molder and would have been dry cutting asbestos cement pipes in his employment, and that, in fact, they even acknowledged that a high level of airborne asbestos could have occurred with that task, and it might have encroached or exceeded 2 fibers per cc. The hygienist also determined or assumed that the task took 15 to 30 minutes per shift and was shared between the various employees who had worked in the foundry in the area, and therefore found that excess exposures were only occasional and that the shift average was 0.06 to 0.1 fibers per cc. There was a supportive OHCOW doctor's report on file linking the asbestos exposure and this particular worker's employment history with the lung cancer, and the physician's report had noted that the asbestos use was daily, that it was always in the air, that coworkers had been diagnosed with asbestosis. The board, in the end, at the operating level or the first level of decision, decided to accept their hygienist's assessment and that found that there was not enough exposure to meet entitlement criteria in the policy, and that there was not enough to find that there was a causal link between the exposure and the lung cancers. So the WSIB denied it at the operating level. That was upheld at the appeals level at the ARO, and the estate appealed it to the tribunal. Next slide. So this next point is actually not something that's specifically discussed in the decision in terms of diagnosis, but when I mentioned at the beginning, I really feel that it's an important point to be made that you have to be clear about the factual basis for a diagnosis when you're looking at a case. I wanted to speak about this because I think it can be something where you can get tripped up if you assume that should the board have accepted there was a diagnosis that the tribunal will accept that there was clear evidence of a particular diagnosis. So just a word of caution to always check the information in the file, Don't focus simply on exposures and causation and assume that the board was right, that there was a clear diagnosis, because you really don't want to get blindsided if you get to the tribunal and they disagree. So often you're going to be looking for biopsy results, pathology results. Often it's some type of scope that has resulted in, or some type of surgery that's resulted in a pathology report, and often then a clear diagnosis from someone reviewing that report. You may find autopsy results in a file, although that's fairly rare, but it can be done if medical professionals were not certain on the results and the family determined or the worker determined that was what they wanted done. It is something that if it isn't really clear, you may end up with significant legal argument and back and forth on the point of diagnosis. So you really want to avoid that if possible by getting everything as much as possible in the file. And it can be a significant challenge for older cases, especially if something is filed many years later or appealed many years later. You know, cancer, as we know, has been around for a long time, but the level of pathology is much more significant right now. So if the medical testing and pathology was not really done 20, 25 years ago when the diagnosis was made, or even longer, this can be a huge challenge in a case, and it may end up being a significant roadblock. So double check that it is a primary lung cancer. That's what you're wanting to be looking for. Obviously, sometimes they think it is, and then they realize it's actually, you know, it's spread to the lungs, but that wasn't what it was as a primary cancer. If you've been in the system for a while, you may remember a number of years ago, there were a fair number of tribunal decisions that talked about whether it was a small cell or a large cell cancer, and that, you know, one was more likely because of asbestos, one was more likely from smoking. That is now considered an old approach. More recent scientific literature does confirm that doesn't add value for determining whether it's related to the asbestos, so that does not arise in tribunal decisions anymore. But be careful that it isn't a sarcoma instead of a carcinoma or a secondary primary. There have been a couple of cases where people have been denied because of the diagnosis wasn't exactly what the tribunal needed to line up with the evidence. Next slide. So the Ontario policy regarding lung cancer and asbestos is policy 160213. The policy requires 10 years of exposure to asbestos and a minimum latency of 10 years, so meaning from when the first asbestos exposure was and the appearance of lung cancer. If you want the policy to apply, it does require you to be an asbestos worker, which is in quotes in the middle there, and I'll speak to what the tribunal interprets that to mean. But if you do meet the criteria of the policy, meaning the 10 years exposure, then your entitlement should be granted. 10 years exposure and latency, then the entitlement should be granted. If you do not, then the policy directs that the case should be judged on its own merit and looked at still. So if you don't meet the policy criteria, it's not the end of the story. Next slide. So the tribunal has looked at how they interpret this board policy in quite a number of different cases. In general, it's not enough simply to say that you were in a workplace that had asbestos for 10 years in order to meet the policy. You need to be found by the tribunal to be considered an asbestos worker. And what that has been said by the tribunal is that you must have worked either directly with asbestos or with asbestos with asbestos products. If there is simply occasional or incidental exposures in your workplace, such as there was asbestos insulation on pipes in another area or beside you, but you weren't actually the person who was cutting those pipes or doing something with them, you're just simply near it, that's not enough to make you an asbestos worker or to fit your exposures underneath the policy. The other important line, which is not quite as spoken about, though, is the discussion of the clear and adequate history of 10 years. This clear and adequate is not actually defined in the policy, and it's not clearly dealt with in the case law. So to meet this aspect of the policy, generally the tribunal says that if you're going to have what they consider clear and adequate history, just if you fall within the definition of asbestos worker and you have 10 years of exposure. So there's not a lot of analysis of clear and adequate history. The focus is more on proving that you're an asbestos worker, that you have the latency and the 10 years. Next slide. So the key to this particular case was the exposure evidence. As you may recall, at the beginning, I mentioned that the worker had passed away a couple years after his diagnosis. He passed before any of the appeals in his case. As such, it was not possible to have his testimony about either his exposures or the work tasks that he had done. And the coworker testimony was absolutely key. Thankfully, was available, and it was invaluable to the tribunal. Coworkers were able to describe the working conditions, the nature of the worker's job duties, and it was a sharp contrast with what the board's hygienist assessment had included and had assumed. If you may recall from what I said at the beginning, the hygienist said that cutting the asbestos pipes was only 15 to 30 minutes per shift, shared between a bunch of different workers, and therefore exposure was really, like overexposure was only really occasionally. Well, when you read this here, the contrasting testimony from the coworkers was that they were cutting pipes all the time. Many. So I think the total the tribunal thought was somewhere between 250 to 750 risers were cut per day in this relatively small room. There was asbestos dust on all the surfaces. There was no masks. Everyone was blowing around the asbestos to clean up with air hoses. And the picture painted of this workplace was very important by these coworkers to explain what the reality was in contrast to what the WSIB had assumed. Next slide. So the findings of the tribunal obviously were influenced directly by the coworker testimony. The tribunal found that there was sufficient exposure to meet the policy because they said, we're not willing to accept the WSIB's hygienist opinion. They found that the coworker evidence was quite strong, that the asbestos exposure was unremitting, was the language they used, and the tribunal focused on the fact that you don't need to look just at what the worker personally produced himself, but all of the exposures around him every hour, every day, all of the time. Because of their finding also that he had such substantial asbestos exposure, they made the statement that when you have that substantial asbestos exposure, then the smoking history is just really reduced legally to being considered a co-contributor and not overwhelming or the main contributor. And as a result of what they found, they said asbestos did make a significant contribution to the lung cancer, and they did not even need to look at the silica exposure because they had made this finding about the asbestos exposure. Next slide. So the takeaways that I have on this case are, like so many, these cases are often decided on the facts. If you are able to gather exposure evidence as soon as possible when a client comes into your door, whether it be things that they can provide to you, whether they can do testimony, written statements, documents, coworkers' names, and if a worker happens to no longer be available, if they have passed already, then coworkers are such a valuable piece of evidence of what the frequency and the duration of the tasks likely were. The second key point, I think, is that the hygienist assessment at the board, look at it really carefully, figure out, are there any ways to challenge this on the facts? I find personally that I'm more successful if you can challenge a factual basis of something. I'm not a hygienist, so I can't challenge the standard amount that a particular task, like that the hygienist says cutting pipes causes 2 fibers per cc of airborne asbestos. That's not something I have a personal ability to challenge as a lawyer, but either if I can find people who even are lay people who were in that workplace who can say, well, yeah, maybe that's how much it was, but instead of just being once a day, it was 10 times or 20 or 100, whatever. That's where you're going to be able to have most success at challenging the hygienist. Also, I mean, in some other cases, it's about if the hygienist just got the work history wrong about what they did and documents about that. But lastly, I think the big thing is to remember that smoking is not a disentitling factor under the policy. The tribunal has noted, the policy doesn't even mention smoking history as something the board should consider. The focus is just simply on, is there an adequate history of asbestos? And when was the cancer, in terms of when was the onset of it after the latency period? If that is met, entitlement is granted. So if you're able to meet the criteria of the policy, then smoking should not really be considered as an offsetting factor. Next slide. So one last slide before my section is over. I wanted to let people know something. It's sort of a related point about lung cancer and asbestos. The facts of it are actually not activated by this particular case study, but I thought it was important to know. I've recently become more aware that the WSIB is sometimes using a different approach to the policy for historical asbestos exposure, in such that they don't always require at the operating level that you have that 10 years that are listed in the policy. We've seen it in some decisions and from the operating level, as well as there's this one-sided decision at the bottom here where an employer took an appeal all the way to the tribunal that included this type of issue, is that the board has been, and this is their own language, favorably considering claims for lung cancer if there's airborne asbestos exposure of only 2 years prior to 75, or weighted as to comprise 5 years between 76 and 83. So I think this is really important to be aware of. If you're looking at a case and someone's come through your door that has something to do with lung cancer and asbestos, there's not always a requirement that it's the 10 years to meet the policy. The board itself, even at operating level, does allow some with even as low as 2 years, as long as it was that significant historical exposure. So I think if people are aware of that, it will help you have a better judge of the chance of success even at the WSIB. Thank you for your time.
Before we move on, we just want to check to see if Meredith was able to get on the line. Hi, Meredith.
Hello?
Hi, that's much better.
Hi. Oh, okay, there, I'm on the phone now.
Okay, perfect. All right, so we will hand it off to you now.
Okay. So many technical issues, so fun. Okay. Sorry about that, everyone. Thank you so much for allowing me to speak for just a few minutes, and I'll keep it short to account for all those tech problems. Just a very brief introduction. I'm a lawyer at IAVGO. IAVGO is a community legal aid clinic in Ontario. We represent exclusively injured workers. Most of our clients are vulnerable and precarious workers, and we have a special practice and interest in working alongside migrant workers in Ontario who have suffered injuries or diseases and their survivors. We are like a direct service community legal clinic. So we serve low-income workers, but we are also happy to provide case consults and strategy sessions and discussions with reps. And we do also provide direct service. So I encourage you to reach out if we can be of any assistance. You can find us at iavgo.org, as well as Twitter and all that stuff. So again, we are there to assist if we can. Turning to the next slide. Today I'm going to review some legal principles and really basic evidentiary thresholds that you or if you're a worker or survivor or you're helping a worker or survivor may face if you're trying to seek entitlement for occupational disease in a claim in Ontario. So, and I'm also going to make some comments about medical and expert evidence and resources to identify whether there may be a case for entitlement for an occupational disease. Next slide. The case I'm discussing is decision number 9-1805. It's a decision of the Workplace Safety and Insurance Appeals Tribunal, which, as I'm sure you will know, is the final level of appeal for workers' compensation cases in Ontario. And I think it's worth mentioning as it always is, how long and how hard workers and families have to fight to even get their case heard at the WSIAT. And that's certainly even more so the case for survivors and victims of occupational disease. The family of the firefighter, the spouse and the family of the firefighter in this case had, fought for many years since his death in 1989 to have his case adjudicated, and it was just adjudicated, decided finally in 2016, and that does happen. So that gives you a picture of the kind of extent of the work that's required by workers. So the worker in this case was a firefighter, and his case was brought along with 8 batched appeals by a group of firefighters who had worked together, particularly had fought a really toxic fire together in 1987, and all of whom developed cancer some years later. Next slide. A picture of this man. He developed cancer in 1989, and he died just a month or so after diagnosis at only age 32. He was a non-smoker. There was a question around the diagnosis, which sort of speaks to Laura's point, and it can be a problem in a case where it was unclear whether the primary site of cancer was the lung or the liver. And he had been a firefighter, at his young age, only 7.5 years before his death in 1989. Next slide. Now, in this case, despite the fact that the worker died so quickly following his diagnosis, his representatives and co-workers and supervisors were able to get really good evidence about the exposure history, and as a result, the panel that heard his case accepted both the testimony and the documentary evidence that the worker, as a firefighter, did have exposures that were relevant for cancer and potentially exposed him to developing cancer. In particular, they accepted evidence that the use of protective equipment in the 1980s was inadequate, and that there were a number of unsafe practices. And they accepted quite a high exposures at the 1987 fire that all the workers in the batched appeals had attended. The tribunal did reject as too speculative evidence of the worker's widow that he also may have been exposed to asbestos in previous car factory work. Next slide. Now, before I continue into the legal analysis, I just wanted to, since we are talking, as I am, just as Laura, talking about cases where the workers are anonymized, they're just their names are protected, we don't have a lot of details, just to give a little bit of a face. This is a picture from IAVGO's photo project, which represents a number of workers and survivors who are directly affected by workplace injury and disease. This is Suzanne Auger, whose husband, Robert, died of mesothelioma in 2000. Next slide. Okay, the basic legal test that the panel addressed in 91805 is whether the work, and this is the test that applies generally in workers' compensation throughout Ontario, is whether the work exposures were one significant contributing factor to the development of the injury or illness. And that has to be established on a balance of probabilities, meaning it has to be shown it's more likely than not that the work exposures were one significant contributing factor. Now, what the heck does that mean? The idea of a significant contributing factor is kind of legalese that really just amounts to saying the workplace exposures have to have been one more than trivial contributor to the development or the acceleration or progression of the worker's disease. It does not mean that the work exposures have to have been the main cause or even an equal cause with other causes to the development or acceleration of the disease. The test is that it has to have been one non-trivial part. And that test is so critical because that's the test that workers would have to prove if they were able to sue their employers. Because of the historic trade-off, workers in Ontario are not able to sue their employers, and as a result, it's critical that this is the test they have to meet, because this mirrors what you would have to meet if you were suing your employer in court. You don't have to show the work was the main cause of your workplace injury. Next slide. However, I gotta say, in the case of occupational disease cases, like this firefighter who developed cancer before the tribunal, there is a pretty rigorous test applied to what makes it likely that the tribunal will decide that the workplace exposures were a significant contributing factor to the worker's injury or disease. And I'm going to try and explain this. I'm no scientist either, so I'm going to try and explain this in as layman's terms as possible. I do recommend it if anyone is dealing with an actual, helping out with a case, is a family member, is a worker, to look up these cases that I've cited and some of the other cases that discuss this. But in essence, the tribunal has said, listen, there has to be a standard mortality index or a standard incidence ratio of 2.0 or higher in the scientific literature. What the heck does that mean? Again, I'm not a scientist, okay? But my understanding is that essentially it means that the ratio of expected deaths in a particular group of workers in a study group has to be higher than would be the expected rate of death in the general population, and it has to be 2 times higher. So it has to be 2.0 or higher, which makes it the risk. There's a 100% additional risk. The logic is quite technical about why they think that meets the significant contributing factor test. So I'm not going to get into it, but there's a very interesting discussion and great submissions and work where advocates are trying to bring that down, because it really has been a very rigorous test that has meant that many workers are unable to prove entitlement where the science is developing or somewhat unsettled, because much of the science will fall somewhat short of that 2.0 number. Next slide. So the advocates in Decision 91805 very smartly tried to reorient the discussion to a recent Supreme Court of Canada case that is a really terrific little case if you have a few minutes to read it. A case that was released in 2016, have the site there, called the Workers' Compensation Board Tribunal and Frazer Health Authority. This is a case out of British Columbia, a case of 3 women who developed breast cancer, all of whom worked together as lab workers in a hospital in BC. And at the tribunal in BC ultimately allowed the workers' case on a really like a common sense and logical inferences type basis. So in that case, there had actually been a study of the workplace itself. And the scientists who did the study, like a scientific study, the scientists who did the study were unable to establish a causation. They were unable to say, yeah, we think these cancer cases are work-related. However, the tribunal looked at it. What they looked at the fact that there was a cluster of cases that was significant. They looked at the fact that there was some evidence of historical exposures to carcinogens, and these ordinary common sense and logical inferences to allow the cases. Based on the benefit of the doubt, they believe the workplace was one significant contributing factor to the workers' cancer. And the tribunal said, there's no need for scientific certainty. And the Supreme Court of Canada upheld the tribunal's decision on all of those points. Next slide. Now, Decision 91805, the WISIAT, not surprisingly, agrees with the Supreme Court of Canada and Frazer Health. You do not have to meet a scientific standard of proof, and causation can be inferred from other evidence, including clusters and common sense. But there's a number of caveats that the WISIAT added to that to really apply that to the case at hand, and these are really important to note. So the WISIAT noted that the benefit of the doubt that falls to the worker only applies if the evidence is about equal in weight on both sides, like for and against entitlement. Also, the panel noted that the absence of evidence is not going to be sufficient to establish entitlement. You can't say, well, there could be evidence, there might be evidence. The speculation is not going to be sufficient. You can't say, well, it's logical that there might be a connection is not going to be sufficient. A doctor opining that there may be a connection is generally not going to be sufficient. And the possibility of work-relatedness is not going to be sufficient. And common sense will not override those requirements in a general fashion. Next slide. So in its holding, ultimately the tribunal rejected entitlement for this worker's spouse and his estate. The panel determined that the epidemiology, the science, was insufficient to show a relationship between the worker's exposures as a firefighter and liver or lung cancer. They were particularly troubled by the short latency period, which Laura talked a little bit about what latency periods are. So the time between the exposure and the development of the disease here was 7.5 years. And that was a big factor in the decision. Also, the panel noted that cancer clusters, they would expect to usually consist of the same type of cancer, and that was not the case here. And so they determined there were no special reasons to allow the case. and they, especially noting that the science established a standard incidence ratio of less than 2.0. One really important point about this decision is that it appears, although again I'm relying just on my reading of the decision, I wasn't involved in litigating the case, that the only up-to-date, detailed medical expert legal opinion, a medical legal opinion, was from the tribunal medical assessor. So there doesn't appear to have been any additional medical opinion, for example, from a worker treating doctor or from an OHCOW doctor. Next slide. So just to bring us back again to the workers directly impacted, this is Mary Beth, who lost her husband to work-related lung cancer in 2001 after 38 years of marriage. Next slide. Okay, my takeaways from Decision 9-1805. The legal standard is not scientific certainty. So that's well established. The recent Supreme Court of Canada case is terrific on this principle, but it is more than possibility. And so if your science is showing just a possibility of causation, it's going to be a challenge to get entitlement. So undeveloped, underdeveloped science is a major challenge for proving claims. Next slide. In this case, the worker's estate was able to establish many of the exposures that the worker suffered because of co-worker and supervisor testimony. But it is really important to keep in mind that if you have you're in contact with a family, you are a worker, you're a family member worker, you're a rep, and you are working with a client who's very, very sick and likely to die, it is important to try and gather that exposure evidence urgently, because the evidence of the worker directly about their day-to-day job duties, their exposures, is often the or one of the most critical pieces of the evidentiary puzzle at the board and the tribunal. So there's a couple of things to think about. One may be a request to OHCOW to do an expedited hygiene review as soon as possible with the worker to hopefully capture that evidence, as well as other good options are affidavits, video testimony, the video statements, any other ways to record the worker's evidence while it's still available. Next slide. It's really important. It's really, really important to get expert evidence on causation. There are ways to get that are practicable for people. You can go to OHCOW, which does provide free medical legal reports. You can sometimes get good reports from treating specialists, sometimes from hospital occupational health clinics. It is not great to have to be relying on solely what board doctors might have said to WSIB in the file or what a tribunal medical assessor might say. It is better to try and marshal your own evidence, if at all you can. And similarly, you want to get the best possible evidence you can on exposure. So Laura already talked to the importance of coworkers, other witnesses. That can be so critical. Another option is to have OHCOW do an occupational hygiene assessment if that is possible. And that can sometimes counter some of the errors that might appear in, for example, the WSIB occupational hygiene assessments that can have mistakes in them. A really important thing to remember is you do need to, if you're going to be a rep or a worker, a survivor, and you're actively involved in one of these cases, you do want to, of course, understand the science. You want to learn. But what you probably don't want to have to do is too much of your own epidemiological analysis. So you probably don't want to be in a position of having to, dissect and analyze and criticize scientific facts based on scientific literature yourself. It's totally appropriate to do legal analysis, and it's also really appropriate to not just defer to experts, because that's also not a great strategy. But if you can at all, you want to have people who are experts both help you understand the science. So if you can find a doctor who will just talk to you, or a scientist who will talk to you and just explain things, you can call OHCOW and ask them to explain things to you, you're 5, just explain it simply, and their hygienist can help you do that. So you do want to learn, but you want to also have that expertise to back you up, so that you're not having to do all that analysis yourself, which is really certainly beyond my abilities as a lawyer. Next slide. So if you don't know whether there might be a case for work-relatedness, and you are a worker, you are a survivor, or you are a rep or a doctor or whoever, here's some just general resources that may be a good place to start. Just if you have you have questions in your mind about whether there could be a connection between the worker's disease and the workplace. So here's some links that are a good start. I will remind you, just my own little lawyer thing, is that workers, survivors can file WSIB or seek legal advice about filing a claim even before determining how strong the science is and the evidence is. So, there's not necessarily a reason to wait to ensure that the science is strong before moving forward, at least with the claim. Last slide. Okay, that's me. This is a picture of Jean and Barb, whose husband and father was also a victim of occupational disease. Thank you.
Thank you, Meredith. Before we move on to Dave's presentation, I just wanted to give a friendly reminder to everyone to please mute your lines if you haven't already, because we can definitely hear everything in the background. And because we are going over a little bit into our Q&A, we are still going to try and get to all the questions. So if you have any, please direct them to the chat box. And if we don't have time today to get to them, please feel free to email them to info@carexcanada.ca, and we'll get back to you as soon as possible. And I will hand it off to Dave now for his presentation on case studies. Dave?
Yes.
Thank you.
Hi. Like Meredith and Laura, I am trained as a lawyer and started out in this line as a student at the Advocates for Injured Workers Student Legal Clinic at the University of Toronto, but all the way back in 1990 in my case. And then worked for the Injured Workers Community Legal Clinic, the Office of the Worker Advisor, IAVGO for 15 years, and then 6 at the Building Trades Workers Services before starting at OHCOW in 2015. OHCOW is a labor-directed organization that provides occupational health services to workers and unions. As Meredith mentioned, we do retrospective exposure profiles by occupational hygienists in individual cases, and also medical legal reports from doctors, but also very importantly, work on current issues in the workplace with hygiene and physicians and ergonomists and occupational health nurses, and assist workers and unions with making interventions to make their workplaces safer. So this case that I'm going to review is called by me the Horserace case for reasons that will become apparent, and it is a uranium miner who contracted lung cancer. Next slide, please. So he was diagnosed at age 68, which was 18 years after he stopped working as a miner, and 29 years after he quit smoking. Very importantly as well, his smoking history was not all that significant compared to many others. 2 to 6 cigarettes per day for 23 years. And again, he quit 29 years prior to the diagnosis of lung cancer. He also did some work while in the mines as a development miner, which is has less ventilation than production mining. And other occupational exposures were not considered relevant by the Tribunal in this case, although I have an asterisk there to indicate that he did have significant diesel exhaust exposure outside of the uranium mines. Next slide, please. The way the WSIB deals with a case like this is to apply their policy on lung cancer in uranium miners. The policy sets out a formula for calculating a radiation index, and then there are different benchmarks that one needs to meet depending upon age at the time of diagnosis. And all of that goes back to the biological effects of ionizing radiation report from 1998. And there's a series of these reports that's still been ongoing from the National Academies of Science in the U.S. If you reverse engineer the formula that they set out, it takes a formula for calculating risk in the Beer 4 report and gives you a finding of work-relatedness whenever you reach a relative risk of 2.0. And this, as mentioned by Meredith, that is then thought to be the equivalent of it being more likely than not in the individual case that the cancer was caused by the work exposure. The problem, of course, is that that's just wrong on many levels. So next slide, and we'll talk about some of those ways that it's wrong. So in the usual case with multiple causes, WSIB is no good at it. They can only go one cause at a time. If they have a policy, they'll apply this policy. If he had also had, say, 10 years of work in a gold mine policy, they would then apply the gold mining policy. But they're not great at looking at the facts of the individual case and how multiple exposures will play in with each other. Even in cases where it has become very well accepted that some things work together. And a good example of that is cigarette smoking and asbestos to cause lung cancer. So Laura mentioned it's not something that should be taken into account, and that's because they will work together in a multiplicative way so that smoking does not take away from the effects of the asbestos exposure. If the asbestos exposure has doubled your risk, it's doubled the risk for a smoker just as much as it has doubled the risk for a non-smoker. So the WSIAD is better at this, but this case is a very bad example of falling into that relative risk of 2.0 trap, and some worse things that we're coming right up to. So it looks at 5 different lung carcinogens: radiation, silica, arsenic, diesel exhaust, and smoking. And for those of you who don't practice in the area or from other provinces, a panel will often, when they're going to refer something to a tribunal medical assessor, first do an interim decision where they set out, here are the relevant exposures, here's how many years we think they were exposed to silica, arsenic, here's how many pack years of smoking, etc. Next slide, please. So a tribunal medical assessor comes from a list that the tribunal chair can establish. They can refer questions or workers for exams to those assessors in individual cases. It's meant to be health professionals who are members of a college regulated under the Regulated Health Professions Act, and excludes employees of the board of the tribunal or any physician who's been involved in assessing the worker or treating the worker, and any physicians related to those physicians as partners and so on. And as noted on the last one, the tribunal can order a worker to appear for an examination by an assessor, and the worker then has to go or have their hearing suspended and even their benefits cut off if they have ongoing benefits. But in the overwhelming majority of cases, these are just paper reviews based on the assessor reading the interim decision and the other case materials, and then answering questions put to him or her by the tribunal. Next slide. In this case, the assessor was a PhD occupational hygienist, which has an asterisk next to it because hygienists are not members of a college or health profession as defined in the Regulated Health Professionals Act. I'm not sure of the implications of this because I don't know that it's ever been contested. it may simply be that the tribunal does not have as much authority to simply order or refer a question out without hearing from the parties first, that sort of thing, because certainly they can do investigations in a case aside from sending things out to an assessor. So this hygienist calculated relative risks for the different exposures in the particular case, and you can see ranges for some of them, and then makes this statement: it is sometimes assumed that a risk for a single disease is increased additively when the worker is exposed to more than one agent that can cause a disease. However, this principle is applied when the biological mechanism is well known and identical for all agents being considered. This is not necessarily the case here, and it cannot be assumed that exposures to these agents additively increase the risk of lung cancer for this particular worker. And the more I've thought about this case over time, the more convinced I am that this is something that is sort of narrowly true, but broadly very misleading. And that almost to just throw this out here like this, and the context does not really help, but it's inviting in some ways the sort of overinterpretation that the panel has done here. Next slide. So the panel takes this and assumes that there's no interaction between any of these exposures at all, that each one represents a separate, distinct causal pathway to lung cancer. So there's no additive interaction. Again, all he said was, you can't assume there's an additive interaction. They assume there's no additive interaction, no greater than additive, or even less than additive interaction between the various exposures. Each one is a separate cause. So that would mean that a tumor could only have one cause off of that list of 5. And within that scenario, they take the relative risks as estimated by the assessor, take the midpoint of each one, and then translate that into probabilities that the cancer, that it was the cause of the worker's cancer. And one element of this that becomes important a little later is that it's reasonable to use the midpoint because the extremes of each estimate are equally as likely to be true. So it's reasonable to take the midpoint, and then they compare those. Next slide, please. And then here's what they do with it. They take the midpoint, set it out here in this table, and then translate it to mean that for radiation, there's a 43% of probability of the agent causing cancer, but a 57% probability that the worker would have developed cancer even without the occupation, even without the exposure to radiation. And they run down the list with that and come to the conclusion on the next slide. Given these percentages, it follows that it is more probable than not that the worker would have developed lung cancer in the absence of his exposure to each of the occupational agents at issue in this appeal. Of these potential cancer-causing agents, the most likely contributor to his lung cancer was the worker's smoking history, which placed him at a 50% risk. Next slide, please. This is wrong in so many ways that it's almost hard to conceptualize it. So it confuses statistical probabilities with the weight of the evidence, which is a legal standard. It is, I think, clear that a relative risk of 2.0 is not sufficient to prove causation. It's neither necessary nor sufficient. So it's not sufficient if you think of things like poor study design. If I have a study that shows a doubling of the risk of non-Hodgkin's lymphoma after exposure to benzene, but there's no increase in acute myeloid leukemia demonstrated in the same study, it's a bad study. That's actually a selection criteria used by the writers of meta-analyses of epidemiological studies to exclude benzene studies as just being poorly designed, maybe even for reasons that you can't quite put your finger on, but AML would be more, you would see more cases, and if you see none, there's something going on with your study design. And also confounders. Do we even know what they are? Are they properly controlled for? And that plays both ways. Could also be what is preventing even a series of studies from demonstrating a relative risk of 2.0. Aside from the issue of susceptible subgroups, or there may be other exposures that greatly increase the incidents that aren't found in your group but are found out there elsewhere in the general population. So unknown interactions. And it's also not necessary to prove causation when we know what we're talking about, which I think is a very important point, though I'll mention several times here. It doesn't matter what the relative risk for school janitors is, that they contract mesothelioma or really any other occupation. What's necessary is to demonstrate asbestos exposure in an individual case, because we know that mesothelioma is caused by exposure to asbestos. And at that point, where you have some knowledge of the causal link, where the knowledge is real, the circumstantial evidence that you get from epidemiological stuff, that somehow in a legal proceeding. Either you can demonstrate the asbestos exposure or you can't. But what happened to a bunch of other school janitors who were in a study somewhere, maybe in another country, can't trump that. It destroys the significant contributing factor test in this particular case and applies a predominant cause test, really a sole cause test. And the most important part of this is contrary to the evidence. If they got the facts right, it wouldn't be destroying that test necessarily, but here they did. And more importantly, it really destroys the benefit of the doubt test, which is the statement in the Act that on any given issue in a case, if the evidence is relatively equal for or against the claimant, the benefit of the doubt goes to the claimant. So think back to the ranges that the hygienist gave, and the basis of comparing them in the way that the panel did. So if the extremes are equally likely, and all of the estimates can be directly compared, then it's equally likely that smoking comes in tied for last as a potential cause of this disease, because it's equally likely that radiation had a relative risk of 2.0. Silica had one of 1.75. Smoking tied with arsenic and diesel exhaust for 1.5. But somehow there's a total blind spot for that consequence of the way that they're reasoning with the risks here. It also ignores the evidence of significant interactions between smoking, silica, arsenic, radiation, and diesel exhaust mentioned by the assessor himself in the Beer 4 report, in another medical report from an OHCOW doctor in the file, and misconstrues how epidemiology works. So Meredith already cited this decision 697, which is probably the leading one on this relative risk of two question. But what's being assumed here is that if you had a standard incidence ratio of 161, and then I'm just throwing in out of, say, 20,000 people, that would mean that 100 of those individuals, of the 20,000, would have contracted the disease without the occupational exposure. And therefore, it's more likely than not that each of those 161 individuals, since we don't know anything else, would have contracted cancer even in the absence of the occupational exposure. But it's a total misapplication from a population level to an individual level. To be able to do that, we'd need to know to perfection that the sampling and the controls for other exposures and susceptible individuals and so on were known and accounted for. Because all epidemiology tells us is if we took those 20,000 people and spread them out in the same way that the general population is spread out with all of the other causes of cancer, occupational, non-occupational, etc., we would expect that only 100 of them would get cancer. And it may be, it's certainly not necessarily 100 out of the 161. And we don't have the information to say that. And if we did, we would be able to identify who the 61 were, who had the occupational causes. And again, mesothelioma is a good example of this. Those relative risk findings just don't have applicability legally or practically in the adjudication of cases in an individual case where you know what the causal factor is. The evidence, which is a recent Supreme Court case that Meredith mentioned as well. A worker was exposed to 4 occupational carcinogens at levels that are known to cause cancer, yet no role is what it means to say it's not significant. It did not change anything. And that's based on a minor difference in imprecise calculations, sort of guesswork on estimates of relative risk. And again, along with not giving the benefit of the doubt to the worker. Next slide. So smoking shares causal pathways with all of those occupational exposures. Maybe more importantly, they share causal pathways with each other and definitely work in an additive way and probably even a multiplicative way with silica and smoking, for example. Plus, identical mechanisms are not necessary for additive or greater than additive interactions between them. Again, that statement, insofar as it's narrowly true, would be true that you need the exact same mechanism and also that there's no sort of saturation level of exposure or anything like this. That's important for it to be strictly additive, that it's exactly the same thing. But in fact, there are lots of complementary actions and potentiations and so on between different carcinogens that are necessary to produce cancer. Plus, the actual epidemiological evidence shows there are significant greater than additive interactions between smoking and all 4 of those occupational carcinogens in this case. So one practical lesson is it's unfair to second guess because you couldn't have guessed that for in this case, but it is possible to submit reply evidence to an assessor report if there's anything that seems a bit wonky and that might need to be replied to. OHCOW can potentially do that. Certainly we can take a quick look at it and let you know if further work on our part might be helpful to you. And then next slide. So there is hopefully going to be some more guidance on this issue of multiple exposures coming in the near future. Paul Demare, who is the director of the Occupational Cancer Research Center and is both a PhD in epidemiology and an occupational hygienist, commissioned by the Ministry of Labor to produce a report on this issue. Liberal government first set it up, and then it was confirmed by the new Progressive Conservative government. It arises out of the GE Peterborough cohort. do in almost every case, but will have effect across the board. And the next slide, his mandate is to answer three questions, look at three questions. How can scientific evidence best be used in determining whether a cancer is work-related, particularly in cases of multiple exposures? Are there any best practices in other jurisdictions that Ontario should consider adopting? And as scientific evidence evolves around occupational cancer, what criteria should the Ministry of Labour consider in developing legislative policy? His report is expected in by the end of this year. And that's it from me.
All right. Thank you very much, Dave. So I realize that we are at time. It's 1:30, but we are going to let Anya finish off with some concluding remarks. So anyone who can't stick around for the remainder presentation, we are recording it. So we will be sending out the full presentation when it's available, as well as an extended version of the slide deck. So I will hand it off to Anya. Thank you.
Hi, everyone. Can you hear me okay, Chantal?
Yeah, we can hear you.
Okay,
sounds great. Thanks.
Just checking on the technology. So hi, everyone. And thanks, Cheryl and Chantal and the CAREX team for the opportunity to provide some summary comments before we open things up for questions and discussion, if we have time. As Chantal mentioned, I'm an occupational and public health consultant, and I've worked with CAREX since its inception. My training is in chemical engineering and occupational hygiene, and over the course of my career, I've worked in various capacities along the research and policy spectrum. I began my career performing retrospective exposure assessments for occupational cancer studies here in BC, and spent 8 years working at WorkSafe BC, first in regulation and occupational disease policy, before taking on responsibility for building their research function back in the early 2000s. Since leaving WorkSafe in 2004, I've consulted for CAREX and other research institutions, and for the past 5 years, I've also assisted retired workers or their families in several provinces to develop complete occupational histories to support their occupational disease claims. So over the next 5 to 10 minutes, what I'm going to do is pull together the common threads of the 3 case studies we've just heard, touch upon some of my own experiences in assisting on these kinds of claims, and then just finish by walking through a tool that was first created by Kay Teschke and Ray Brands at UBC that I have found particularly useful when building a picture of a worker's occupational history and the trajectory of his or her working life. Next slide, please. Cheryl began the webinar by alluding to 2 of the key reasons why these cases are so challenging. The need to collect evidence of exposure and the need to not only show medical causation, but also to meet the test of legal causation. All 3 of our case studies offer insights into the adjudication process and clearly illustrate how challenging and time-consuming it can be to get these claims accepted. So starting on the exposure side, one of the key issues that we face is how do you establish that a worker had sufficient exposure to cause the disease when the exposure happened years or decades in the past? How do you come up with an estimate of exposure in the absence of historical records or monitoring data? As our case studies illustrated, you begin to build a picture with personal and coworker testimony, supplemented wherever possible by monitoring data and by expert advice from occupational hygienists and exposure scientists. Another key issue that was highlighted in the case studies is that exposure doesn't happen in a vacuum. Workers are rarely exposed to just one carcinogen. So how do you factor in multiple exposures that may also have played a factor, and how do you factor in a confounding exposure like smoking? We also heard about the challenges arising from the need to establish both medical and legal causation, the use of a relative risk of 2 to establish the threshold of entitlement, and how common misunderstandings about the science of epidemiology may result in claims being denied. Laura's case study highlighted the necessity of differentiating between general causation, is there a link between the disease and exposures, and specific causation, is there a link between this worker's disease and his or her exposures. As Dave pointed out in his case study, epidemiology can answer the first question, but it cannot answer the second. Epidemiology is useful in determining whether a risk of developing a disease exists in a particular population of workers. It cannot answer, and it should not be used to answer, the question of whether an individual worker developed a disease as a result of his or her job. To answer the second question, the focus must be on exposure, not on the occupation. And as Kay Teschke pointed out in a letter to the editor of the Annals of Occupational Hygiene in 2015, a job cannot cause disease, its exposures may. So this is why we found it useful and vitally important to build a comprehensive occupational history for the various requests that we've gotten through CAREX, a history that drills down from the job to the specific tasks performed, and that takes into account not only the level and duration of exposure, but also how the levels of exposure vary depending on such factors like how is the task performed, whether the task is performed in isolation or around other workers, and the availability of control measures like ventilation and personal protective equipment. So just before wrapping up, I want to just quickly walk through a tool that I found useful for creating an occupational history. And as I mentioned earlier, this tool was created by Kay Teschke and Ray Brands at UBC. And I will make it available to Cheryl and the CAREX team, and we can arrange to share it along with the slides when they're shared. So next slide, please. As this slide shows, and also the next, the occupational history that we create is framed around 4 key themes. How much exposure? How was the worker exposed? How long did the exposures last? And was there non-occupational exposure to carcinogens? So in thinking about how much exposure, what we aim to get at is the intensity of the exposure. So in the absence of actual monitoring data, we begin to build a picture by asking the worker to visually describe what happened when they performed the task. So for example, dust was visible in the air, the equipment was coated with dust at the end of the day. If the exposure occurred as a result of how a particular process operated, we ask them to describe those processes as completely as possible. So, for example, small fragments of material fell down onto my face and arms while I scraped insulation off pipes. As both Laura and Meredith pointed out, co-worker interviews are very helpful at this point in painting a picture of exposure and in supplementing our understanding, or in some cases contradicting assumptions that have been made by the adjudicator or by board hygienists when they were reviewing the claim. I recently worked on a claim for acute myeloid leukemia where I had initially suspected that the worker had been exposed to benzene and solvents. But a conversation with a coworker revealed an intermittent but regularly performed task that resulted in the worker having repeated exposure to bunker C fuel oil over the course of his employment. The other thing that our case studies highlighted was the importance of knowing how a worker is exposed. So the kinds of information that we try to collect to create these occupational histories are things like, was there exposure by inhalation? If yes, was there ventilation in place to prevent exposure? If yes, was it used? Was it local or general ventilation? Was the worker provided with personal protective equipment? If yes, were they trained on how to use it? And did they use it? And if they did, how often? In my experience, if a worker says they've used personal protective equipment, it's also often helpful to have them show you a picture of it. I worked on one claim where the worker said that he had worn a mask when working with asbestos fibers in a fume hood in a lab in Ontario. But with a little probing, it came out the mask was just a face shield and that the fume hood would likely have offered little protection as it wasn't fully enclosed and the air was being drawn up past his breathing zone. So these kinds of, or these pieces of information, coupled with monitoring data, if they're available, either from the actual workplace or from studies of similar workplaces, can help generate an estimate of the level of exposure that a worker had. Can we go to the next slide, please? So in addition to collecting information that helps us determine the intensity of exposure, it's also important to collect information to determine how long the exposure lasted. This process involves estimating both the worker's typical daily exposures and the period over which these typical daily exposures have been repeated. Since there can be considerable variability in how tasks are performed or in the processes that give rise to exposure, it's also important to ask the worker to estimate their average daily exposure over a longer period of time. And then once we have this information, we can then try to express it in a standardized format that indicates the cumulative duration of exposure. So, for example, the worker was exposed as a heavy-duty mechanic to benzene by inhalation for 2 hours per day times 3 days of work per week for 12 years. And then finally, Dave's case study illustrated the importance of overlaying the occupational history onto the worker's life trajectory. So in addition to creating a history of exposure to workplace carcinogens, it's also important to ask about non-occupational exposure to carcinogens, as well as whether or not the worker has ever smoked. Although a history of smoking can mistakenly be used to deny a claim, creating parallel occupational and life histories can often illuminate situations where adjudicators and medical experts have either neglected to factor in that the worker had quit smoking, or that they didn't take into account that smoking can amplify the effect of exposure in either an additive or a multiplicative way. So that is it for me, and I will turn it back to Chantal and Cheryl if you have time for questions.
Perfect. Thank you so much, Anya. That was a really good overview, and thank you for tying together all the common threads. I just wanted to apologize again to our audience for the late start and technical issues. We will be sending out an evaluation following the wrap-up of this presentation, so please look out for that in your emails, and if you could fill it out, it would be greatly appreciated. We use these evaluations to improve future webinars, and I also want to say thank you to our presenters as well for taking the time and for sharing your expertise and knowledge with us. So if you have any questions for the presenters, please do not hesitate to email us at info@carexcanada.ca. Thank you, everyone.